The Supreme Court just rewrote American gun laws overnight. What was a federal felony 6 months ago is now completely legal in 34 states. But while your Second Amendment rights just expanded, new legal traps have opened up, and relying on outdated rules could still land you in federal prison. If you own a firearm or carry concealed, everything you thought you knew has changed. By the end of this video, you'll know the 10 new rules of gun ownership, which states are fighting back, and the critical mistakes that will cost you your freedom. Let's start with the most shocking change happening right now. Rule number 1. Bump stocks are federally legal again after the Supreme Court's 6-3 decision in Garland v. Cargill. On June 14, 2024, the Supreme Court struck down the federal ban on bump stocks that had been in effect since 2018.
Breaking news, the U.S. Supreme Court strikes down the Trump-era ban on bump stocks. That is a gun accessory that allows semi-automatic guns to fire rapidly like a machine gun.
Justice Clarence Thomas wrote for the majority that the Bureau of Alcohol, Tobacco, Firearms, and Explosives exceeded its authority when it classified bump stocks as machine guns under the National Firearms Act. Here's what this means practically. Bump stocks are devices that attach to semi-automatic rifles and use the weapon's recoil to simulate automatic fire. The gunman in the 2017 Las Vegas shooting used them to fire over 1,000 rounds in 11 minutes, killing 60 people and wounding hundreds more. After that massacre, the Trump administration banned them through ATF regulatory action. But the Supreme Court ruled that Congress, not the ATF, has to make that call. The court said bump stocks don't meet the legal definition of machine guns because the triggers still function separately for each shot fired. With a true machine gun, one trigger pull fires multiple rounds automatically. With a bump stock, the trigger resets between each shot, even though it happens very rapidly. Up to 34 states are immediately affected because they relied on federal law rather than passing their own state bans. In these states, bump stocks became legal to manufacture, sell, and possess the moment the decision was announced. However, 16 states, including California, New York, Massachusetts, and Connecticut, have their own specific state laws banning bump stocks that remain in effect. The legal landscape is confusing right now. In Texas, Louisiana, and Mississippi, you can walk into a gun store and legally buy a bump stock today. Drive across the state line into California or New Mexico, and possession becomes a state crime. This patchwork of laws means you need to know your state's specific rules before purchasing or traveling with these devices. Gun rights groups are already challenging the 16 state bans in federal court, arguing they violate the Second Amendment under the new Bruen standard we'll discuss next. But for now, those state bans remain enforceable. Rule number 2. All gun laws must now pass the historical tradition test established in New York State Rifle and Pistol Association versus Bruen. In June 2022, the Supreme Court fundamentally changed how gun laws are evaluated. Before Bruen, courts used a balancing test, weighing the government's interest in public safety against the individual's right to bear arms. The Bruen standard eliminated that balancing act entirely. Now, to justify any firearm regulation, the government must prove the restriction is consistent with the nation's historical tradition of firearm regulation dating back to the founding era in 1791. This requirement has created chaos in federal courts nationwide. Judges are now acting as amateur historians, researching colonial-era laws to determine if modern restrictions are constitutional. Consequently, courts have used Bruen to strike down assault weapon bans, magazine capacity limits, and concealed carry restrictions from coast to coast. However, the Supreme Court also showed limits to how far Bruen extends. In United States v. Rahimi in June 2024, the court upheld the federal law prohibiting people under domestic violence restraining orders from owning guns. Chief Justice Roberts clarified that modern restrictions don't need to be a dead ringer or historical twin of founding-era laws, just analogous to historical principles. Still, legal experts warn that hundreds of gun laws remain vulnerable. The resulting circuit splits, with some courts aggressively striking down laws while others remain cautious, will likely require further Supreme Court resolution. For gun owners, rights you never had before may suddenly be protected. But it also means the legal landscape is extremely unstable. A law that's constitutional in one circuit might be unconstitutional in another, and what's legal today could be illegal tomorrow. Rule number 3. Concealed carry rights now extend far beyond your home, but sensitive places restrictions are expanding. The Bruen decision established that the Second Amendment protects the right to carry firearms outside the home for self-defense. This overturned proper cause requirements, forcing 25 states, including New York, California, and New Jersey, to shift from discretionary may-issue systems to objective shall-issue permitting. However, states have fought back by dramatically expanding sensitive places where carrying remains prohibited. While the Supreme Court acknowledged governments can ban guns in historically sensitive locations like courthouses and polling places, modern states have interpreted this broadly. New York and California now prohibit firearms in dozens of locations, including public transit, parks, hospitals, and any private property, unless the owner explicitly posts permission signs. This patchwork creates a compliance nightmare for concealed carriers. What's legal in Texas might be a crime across the state line in New Mexico, and local governments often have their own additional restrictions. The Supreme Court granted review in a Hawaii case, Wolford v. Lopez, that could clarify this doctrine. Hawaii essentially bans guns in retail stores unless owners post permission signs. Gun rights advocates argue this flips the constitutional presumption, making carry illegal everywhere unless specifically permitted. For concealed carry holders, the new rule is practically complex. You have a constitutional right to bear arms in public, but that right doesn't extend everywhere. Before carrying in any new location, research federal, state, and local sensitive places restrictions. Violations can result in felony charges and permanent loss of gun rights. Rule number 4. Nonviolent felons are gaining ground in challenges to lifetime gun bans, but the Supreme Court just declined to rule. The Federal Gun Control Act of 1968 permanently prohibits anyone convicted of any felony from owning firearms. This affects millions of Americans, including people convicted of nonviolent crimes like check fraud or drug possession decades ago. Second Amendment advocates have launched hundreds of challenges to this law under the Bruen standard, arguing that colonial-era America didn't permanently disarm people for nonviolent crimes. The test case was Vincent v. United States, involving Melinda Vincent, a Utah single mother convicted of bank fraud in 2008 for a $500 fraudulent check. She argued that losing her Second Amendment rights for life over a nonviolent financial crime violates the Constitution under Bruen. On March 2nd, the Supreme Court declined to hear Vincent's appeal, leaving the Gun Control Act's felon prohibition intact for now. However, federal courts are split. Some have upheld the ban entirely, finding historical precedent for disarming dangerous individuals. Others have created narrow exceptions for specific nonviolent crimes. The Trump administration has taken a mixed position. While defending the law in court, Attorney General Pam Bondi has been given authority to restore gun rights to eligible nonviolent felons through administrative process. For affected gun owners, this creates an uncertain landscape. If you have a nonviolent felony conviction, federal law still prohibits gun ownership, but successful court challenges could eventually require individualized review rather than blanket bans. Some states also have their own restoration processes that may provide relief. Rule number 5. Drug users face a Supreme Court challenge that could reshape federal gun prohibitions. Federal law prohibits anyone who is an unlawful user of or addicted to controlled substances from possessing firearms. This includes people who use marijuana regularly, even in states where it's legal under state law. Recently, federal prosecutions under this law have increased dramatically. The test case is Himani versus United States, currently before the Supreme Court. Ali Daniel Himani was charged after the government alleged he was a regular marijuana user. The Fifth Circuit Court of Appeals ruled that the government must prove someone was under the influence of drugs at the time of arrest, not just that they use drugs regularly. This conflicts with other circuits that have upheld the law as written. During oral arguments in March, conservative justices expressed skepticism, questioning whether occasional marijuana use makes someone dangerous enough to lose constitutional rights. The case puts the Trump administration in an awkward position, creating tension between its signals of support for marijuana decriminalization and its defense of this law in court. For gun owners who use marijuana, even legally under state law or with a medical prescription, federal prosecution remains possible. The Supreme Court's decision in Himani could dramatically narrow this prohibition or eliminate it entirely for occasional users. Until that ruling comes down, federal law treats any controlled substance use as disqualifying for gun ownership. If you use marijuana, understand that federal law still applies, and lying on ATF Form 4473 about drug use remains a federal felony. Rule number 6. Assault weapon and magazine bans are falling in multiple states, but others are fighting back with new restrictions. Federal courts have struck down assault weapon bans in California and Illinois since Bruen, ruling they violate the Second Amendment. Judge Roger Benitez in California called the state's assault weapon ban a failed experiment that criminalizes common firearms owned by millions of Americans. In Illinois, a federal judge struck down the state's ban on selling assault weapons and high-capacity magazines, though the Seventh Circuit has allowed enforcement to continue during appeals. The judge found that AR-style rifles are in common use for lawful purposes and therefore protected by the Second Amendment. But the legal landscape is chaotic. The Fourth Circuit Court of Appeals upheld Maryland's assault weapon ban in August, creating a circuit split that will likely require Supreme Court resolution. Different federal courts are reaching opposite conclusions about the same types of weapons using the same Bruen standard. State governments are responding with increasingly creative restrictions. Washington State banned the sale of assault weapons while allowing existing owners to keep them. Oregon passed a permit system for high-capacity magazines that requires background checks and safety training. Connecticut and Massachusetts are considering ghost gun restrictions that would ban unfinished receivers and require serialization of home-manufactured firearms. These laws target the growing market for build-your-own firearm kits that don't require background checks. The practical result is a patchwork of state laws that change rapidly based on ongoing litigation. What's legal to buy and possess varies dramatically by location. Some states are becoming increasingly permissive, while others are creating new restrictions faster than courts can review them. For gun owners, this means research is critical before purchasing firearms or traveling across state lines. An AR-15 rifle with a 30-round magazine might be perfectly legal in Texas, but result in felony charges in New York or California. The Supreme Court will likely need to establish clearer guidance on what types of firearms are protected by the Second Amendment. Until then, expect continued legal chaos and inconsistent enforcement. Rule number 7.
Happening tomorrow, New York State's newest gun control law takes effect. The red flag law will allow certain authorities to temporarily confiscate firearms.
Red flag laws face increasing constitutional challenges but remain enforceable in most states. 21 states and the District of Columbia have extreme risk protection order laws, commonly called red flag laws. These allow family members, law enforcement, and sometimes others to petition courts to temporarily remove firearms from people deemed dangerous to themselves or others. Gun rights advocates have launched constitutional challenges to these laws under Bruen, arguing they violate due process and Second Amendment rights. However, most federal courts have upheld red flag laws, finding historical analogs in colonial-era laws that disarmed dangerous individuals. The Supreme Court's Rahimi decision actually strengthened red flag laws by upholding gun restrictions for people under domestic violence restraining orders. Chief Justice Roberts wrote that the Constitution allows disarming individuals who present a credible threat to the physical safety of others. But red flag laws remain controversial and politically divisive. While Florida passed the first Republican-backed red flag law, states like Texas, Alabama, and Oklahoma have explicitly banned their enforcement. Implementation also varies dramatically by state regarding who can petition and the standard of evidence required. For gun owners in red flag states, understand that these orders are typically issued ex parte, meaning without your initial presence or input. If you are subject to a red flag order, comply immediately. Violating these orders can result in felony charges, but you will have legal procedures to challenge the order and recover your firearms later. While their effectiveness is debated, courts generally find them constitutional as written. Rule number 8. Private property carry rights are expanding, but property owner rights create new complexities. The Supreme Court will hear arguments in Hawaii versus Carvalho, a case that could dramatically expand concealed carry rights on private property. Hawaii currently requires explicit permission to carry firearms on any private property open to the public, essentially banning guns in malls, restaurants, and retail stores, unless owners post signs allowing firearms. Gun rights advocates argue this violates the Second Amendment by making carry illegal everywhere unless specifically permitted. They contend that the Constitution protects the right to bear arms in public generally, not just on government property. Hawaii and other states argue that property owners have fundamental rights to control what happens on their land, including whether firearms are allowed. They point to historical precedent for property-based restrictions and argue that the Second Amendment doesn't override private property rights. The case highlights tension between gun rights and property rights that Bruen didn't clearly resolve. Currently, state laws vary dramatically. Some states, like Texas, prohibit businesses from banning concealed carry by customers. Others, like California, allow businesses to ban firearms on their property. The patchwork of laws creates compliance challenges for concealed carriers and business owners alike. In Texas, a 3006 or 3007 sign gives proper notice that concealed carry is prohibited, and ignoring these signs can result in criminal charges. In other states, similar signs have no legal force. Some states are moving toward Hawaii's model requiring explicit permission rather than explicit prohibition. New York's post-Bruen law flipped the presumption, making carry illegal on private property unless owners post signs permitting firearms. For concealed carriers, research state and local laws before carrying on private property. Even with a valid concealed carry permit, you could face criminal charges for carrying where prohibited by properly posted signs or state law. Business owners should understand their rights and obligations under state law. Some states protect your right to ban firearms, others may limit that right or require specific signage for legal notices. Rule number 9. Interstate travel with firearms just got more complicated as states create conflicting requirements. The Firearm Owners Protection Act of 1986 created a safe passage provision allowing people to transport properly secured firearms through restrictive states, provided the weapons are legal at both the origin and destination. But state governments are testing the limits of federal preemption with increasingly strict requirements. New York has arrested travelers for firearms during airport layovers. California requires anyone bringing firearms into the state to comply immediately with their magazine and assault weapon restrictions, turning law-abiding citizens into criminals unknowingly. Rule number 10. Federal agencies are being forced to reconsider decades of ATF interpretations under the new Supreme Court standards. The Supreme Court's Cargill decision striking down the bump stock ban has called into question the ATF's authority to make major classifications without explicit congressional authorization. Multiple ATF interpretations are now being challenged in federal court. This includes regulations on ghost gun kits, which courts question even qualify as firearms under the original Gun Control Act, and the 2023 rule classifying pistols stabilizing braces as short-barreled rifles requiring federal registration. Federal courts have reached conflicting decisions on whether the ATF has authority to make these classifications. Meanwhile, the Trump administration has signaled plans to review and potentially reverse rules that exceed the agency's statutory authority, which could deregulate entire categories of firearms.